Hello, how are you doing? Hope you're good. Hope you're fine. Welcome to Lawyers Info Hub. You're welcome, you're welcome, you're welcome. If you're meeting me for the first time, I'm Mercy, your host on Lawyers Info Hub. Is a platform where we create law content. We simplify it in a way that make you understand it. The platform was created out of passion to support the legal education in Nigeria and in Africa. Whether you're a law student, whether you're a lawyer, whether you're just a man who is interested in law, this platform is for you. You are welcome on board. If you are yet to be part of our great family, please do hit the subscribe button. Drop your questions in form of comments. I will answer them in due time and in due course. You're welcome. So today we're looking at when an accused pleads guilty. When an accused pleads guilty. We're looking at facts, review, and sentencing. Now, um, whether for the prosecution or you can be in a position of being a counsel to the accused, and you meet with a circumstance like this where your client or the accused pleads guilty, and the court says, okay, we adjourn for facts review and sentencing. What does it mean? So I'm looking at it from the point of you understanding what to do at that point. Now, in the criminal law proceedings, sometimes it plays out like this. Sometimes you don't need to go through that hurdle of trial, prosecution, closing its case, you filing a notice of no case submission, open defense, cross examination, and all, find a final written address and judgment before, plea of allocutors where necessary, sentencing, and all of that. So this happens in court, and most of the times it could be from the defendant, it could be from the prosecution. They don't even know what to do. So this video want to teach you what that procedure means and what you need to do in that circumstance. Now, when an accused pleads guilty, you see what it means that he's admitting to the guilt. He's admitting to that the commission of that offense. He's guilty, saying, "I did what I've been accused of." Now, some of that time, this plea of guilt comes maybe years after, months after the person has even pleaded not guilty. Now, an accused can elect to change his or her plea. Sometimes, at the point of arrest, at the point of the first arraignment, they'll plead, "I'm not guilty." And maybe subsequently, after a lot of things has gone down, maybe time has passed, they've been in detention, awaiting trial, lots of things here and there, bottlenecks here and there. Maybe someone has talked to them to say, why not admit? Or maybe you really did this, why not admit, so that at the end of the day you have served a portion of your, if peradventure you found you have really served a portion of the duration of time you're supposed to be given at the end of the day. So sometimes this change in plea, there's various factors that contribute to it. It's possible at the point of commission of this crime, someone is telling the accused, say I'm not guilty, to delay time, or so that to go through trials, through technicalities will free you. Somebody is there, yes, I committed this thing, but there are some reasons. There are a lot of challenges or a lot of situations or circumstances can lead to an accused pleading guilty or changing his plea from not guilty to guilty. Now, you are now faced with an accused who has said, I am guilty. Now, for the prosecution, if you're in the position of the prosecution, what you need to do at that point, when the court says, you see that after the person has pleaded guilty, the court will record it and now adjourn for fact review and sentencing. For the prosecution, the burden on you becomes light. What you need to do is the fact review is, the court wants to hear from you what has happened. So you do like a recap of what happened, this person, what he was charged with, the offense, when he was arrested, details of when he has been in the time period of time he has been in detention. What is your investigation report saying? What are those things in your file, proof of evidence that to show that, see, this person committed this offense. you bring it to the court. You let the court know that upon arrest or upon conclusion of our investigation, this and this was what we found out. And then the exhibits you're relying on, you tender it. Are there pictures? You must ensure that the pictures are admissible, they're in the right form, you tender it. To say, okay, my lord, these are what we have in our possession, in our proof of evidence to show that this accused did what he was accused of or what he's being charged with. So, as a prosecution counsel, or you are for the prosecution, this is what you need to do. You just don't need to do it shabbishly. You must do it with as a professional. You know, so the court looking at the fact review, what brought this guy here? He has pleaded guilty. What brought him here? You know, some other time in the course of the criminal proceedings, there might be an amendment to the charge. You also let the court note that at this point, the charge was amended. Maybe 3 people were charged. I know the only one was arrested, and the court is saying, for me to proceed against this one, then you have to withdraw against 2. Or there could be some other reasons why the charge is, or maybe the law has been repealed, or there's a new version of the law, and you're trying to charge under the new law. You can amend. So in that instance, when you amend your charge, the person will be rearranged. Now, you have to let the court know that at some point in that proceedings, you amended your charge, and so the court will also note that. Then you present or tender the exhibit which the court will admit and mark it accordingly. Now, then it's also very important as prosecution to make reference to the law upon which the charge was drafted, or the charge was brought. What is the law saying? You refer the court to whatever it is in the SCJL, SCJA, whichever law that you charged the accused with. You refer the court to that particular section, the punishment section, and the discretion where the law provides the court to also use his discretion in sentence is very key. Now, coming to the defendant, as a defendant who is representing the accused, your client has pleaded guilty to the crime. What do you do? And the prosecution has made a fact review of what has happened from the time of arrest, investigation. Now, at this point, the accused has pleaded guilty. So, what you do also is that you also let the court know that your client, the accused, was arrested the day he was arrested, when he was brought to court, how many years or days or months he has been in detention. Now, this is very key. Peradventure, if maybe the punishment for that crime may be 3 years or 4 years or 6 years or 2 years, and your client has stayed 2 years, your client has stayed 3 years, your client has been stayed 5 years awaiting trial, or your client has stayed even few months. So you need to let the court know, so the court will look at it. It's very critical, because they've seen many people who have pleaded guilty or changed their plea from not guilty to guilty. When the court makes its sentence, you see that they have even overstayed, or they have even served out the term of their offense. So at the end of the day, from the court, release warrant is being issued and all of that, they are being released. So as a defendant counsel, you let the court know these details. You let the court know how many months he has spent. You let the court also, you refer the court to the section of the law on the offense itself, the exercise of the discretion of the court, and the fact that the court has a discretion in terms of sentencing, depending on the crime, depending on the crime. So you must look at the law again, look at the law upon which the charge is being brought, or what is the law saying? Is there an exception? These are the things you need to know, so that it will guide what you're going to tell the court, because the court is going to record you as the defendant counsel. And you urge the court to, exercise its discretion in favor of your client. You'd let the court know, peradventure is a first-time offender, you let the court know. Peradventure, he's the only son of the father of his family. He has changed since his incarceration. He has turned a new leaf. You need to play to the mind of the court. That is not a time for allocators. But for you as counsel, this is time for you to express yourself, defend your client in the most way you can. So what you're going to do, just like I earlier stated, is you let the court know things that will, budge the mind of court to your in favor. He's a first-time offender. Since he got to the into detention, he has turned a new leaf. He has been a better. You think that the period he has spent in the correctional facility has turned to be a better citizen. His age, if he's a young person, let the court know that this person is in his prime, or is a young person who has a lot to contribute to the society. So the court needs to, hear all of this. I urge the court to exercise this jurisdiction in his favor. At the end of the day, the court might there and then, you know, write or its sentence and read it out. Now, or the court can adjourn. But when the court in that instance, makes the sentence, the court will now read out, having considered the prosecution's presentation and the defendant counsel and the exhibit that has been that have been tendered. They satisfied that the accused is guilty of the crime and all of that. But the court also mentioned that he also knows that he has discretion in such a crime or in such offense, and after which the court will ask the court will ask the accused what he has to say, which is what is called the plea of allocators. Now, you saw sometimes in court we see the accused crying, kneeling down, begging, I will not do it again. I won't go back to become a bad egg in the society. I've changed. I've learned my lesson. Different ones, they'll start crying. Some of them will start, after which the court will now pronounce its sentence, which is the court can say, okay, I sentence you to 6 years imprisonment, 4 years imprisonment, 2 years imprisonment, if there's an option of fine and all of that. Sometimes, just like I earlier stated, you've seen accused persons that even have served out or about to complete the terms of the duration of their sentence. So at the end of the day, you see that it's a win-win for both, and it's easy for the court, that one out of the court docket. Now, when an accused pleads guilty, there's also a part of plea bargain, but that's not what this video is all about. On a separate video, I'm going to discuss plea bargain, what it is, how it is done, its advantages, and why it's been, on the increase in our recent times, especially used by Economic and Financial Crimes Commission and other agencies, for accused persons. So just my own concern in this video is to let you know, as a prosecution counsel or the accused person's person's counsel, on what to do when the court, maybe adjourns for fact review and sentencing, or when your client has pleaded for the defendant, the client has pleaded guilty, what you need to do. So I just hope you've learned something today. When an accused pleads guilty, what goes on, what the two parties needs to do, and what the court will do. I just hope you've learned something. If you have a question, please drop it in the comment section, and we will attend to it. If you're yet to subscribe to the channel, please do hit the subscribe button. Join the family, the Lawyers Info Hub. We're here to give you information that will help you as a lawyer, as a law student. We believe in excellence. We want you to be the best wherever you are, because we know that knowledge is a light that's what engulfs darkness, which is ignorance. Don't be ignorant. Know what to do at every point in time. Do take care of yourself, and I know that you can always be the best wherever you are. Do take care.